CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense.
Andrew Frederick, Ms. Lockhart.
Are you Ms. Lockhart?
Yes.
Right. Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I am a female. You keep saying yes, sir.
No, I said yes, Your Honor.
No, you said yes, sir.
I said yes, Your Honor.
I would
Okay.
say I heard yes, Your Honor, as well, Judge.
Okay.
This case starts quietly, but you can already feel how tense it is to stand in front of a judge. Even something as small as how you answer a question suddenly matters. When you're in that chair, every word feels like it can be used against you.
Are you proceeding on the indictment as presented?
Judge, we're going to go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. My allergies are really, I apologize. My allergies are really acting up today.
And Judge, no, I whispered to her that she needs to speak up and not see it. So no.
Okay, that's okay.
Thank you, Your Honor.
Because sometimes people always say that and I'm like, all right. Did you understand the state is proceeding on the lesser included offense of attempted arson, recklessly causing damage as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Actually, Judge.
I believe, Judge, since it's attempted, the arson, recklessly causing damage is a state jail, and since it's attempted, it's a Class A misdemeanor.
Okay, why do you guys have this filled out as a state jail?
It should have been
The
changed.
first paragraph specifically should list it as a Class A.
All right, so you all need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork. That way you can write it in because otherwise
It's difficult.
I don't have knowledge that she knows that it's a Class A because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, it says range of punishment, and it listed up to a $4,000 fine up to a year in jail.
Oh, okay, you are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you, Your Honor.
That's no. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know. Okay.
That's what we did there.
All right. So this is what I'm going to need you all to do, though.
Yes,
I
Judge.
need her to initial it so I know that she knows because all of this is state jail felony paperwork. That's why I say
Okay.
state jail.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. Or from now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, the felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to reflect.
Yeah, we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay, let me carefully read through the paperwork. Just give me a moment to make sure that everything is the way it should be.
This part right here is huge, and most people watching might miss it. The charge was written wrong. Felony paperwork for a misdemeanor case. That's not a small typo. That's the difference between years of consequences and something far less severe. This is why defense attorneys matter and why the judge slowing things down actually protects the defendant.
The range of punishment for that offense is up to $4,000 fine and up to a year in a Bexar County jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
It's to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
When she pleads guilty, she's giving up a lot. Jury trial, confrontation, silence. People think a plea is the easy way out, but it's really a gamble. You're trusting the system to be fair after you give up your leverage.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 North.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out, why were you homeless and why would your father let you live with him now?
Judge, if I could just have a second.
You need to be honest with me because I'm trying to figure out your conditions. And let me just tell you, one or two things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to the Bear County Jail. They're going to do a PSI report and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions.
This is where it gets uncomfortable. The judge is trying to understand her life, but from the defendant's side, it feels like interrogation, not help. Being poor or unstable shouldn't feel like another charge, but in court, it often does.
All right, so why is she wearing yellow today?
I'm pregnant.
Okay, I just wanted to hear it. And how far along?
And then everything changes. She's pregnant, 21, 22 weeks. Suddenly, this isn't just about a bad decision. It's about a future child. You can feel the courtroom energy shift right here.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside, but she understands she's going to take the parenting class going forward because that's going to be her mark.
All right, and is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is a part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
This explains a lot. Medication, mental health issues, competency. This isn't someone trying to game the system. It's someone trying to survive it. Courts aren't designed for nuance, but this judge at least acknowledges it.
All right, I'm going to sentence you to 2 years deferred adjudication. I'm going to want felony drug court referral. They should be able to do it because it's 2 years. And I'm going to want a MIC evaluation. Those are to take place while in custody. And then I'm going to want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs And I'm gonna want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm gonna want field visits one time per month until further notice. Probation, we'll do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm gonna want the UA hotline with testing at least once a week.
Listen to this sentence carefully. Probation isn't freedom. It's rules, testing, evaluations, classes, supervision. One mistake and you're back inside. For someone already struggling, this is a tightrope.
All right.
She was approved. I know that she's being evaluated for mental illness at the MIC caseload.
Mhm.
Being that it's a misdemeanor, but mental health court, I don't think that was approached because there wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea, then the court will consider that.
That's what I was thinking ahead, Judge. That's why my brain was going like, I don't know if it looked like I was rolling my eyes. But I was like, does that mean that she wants? Yes. Okay.
All
I'll
right,
explain that.
so,
Thank
LaShawn,
you.
if you can, you're welcome. LaShawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they are willing to accept her, defense is going to file a motion for new trial and the court will grant it.
But this ending matters. Mental health court could wipe this case away if she succeeds. That's accountability and compassion. Not every case ends like this. And that's why this one sticks with me.